Hello everyone, my name is Amber Holloway and I'm a partner here at our Troy office, and this is the June 2021 episode of my PIP Monthly. Our June 2021 topics include, of course, a case law update. And for the case law update this month, I'm going to do somewhat of a bari overview, a fraud overview of some important cases and some recent decisions that have happened on the bari circuit, so to say. And for trending topics and PIP litigation, we will talk about the Michigan no-fault reform, priority of coverage. We've talked about priority of coverage or order of priority before in my PIP Monthly, but I felt the topic could use another overview since the order of priority changes have just taken effect and some changes have occurred with regard to the MAIPF's decisions. All right, as we all know, bari is our seminal fraud case. It held that summary disposition is proper in a first-party no-fault action where evidence directly and specifically contradicts representations made by a claimant or plaintiff in violation of the policy terms. It held that an insurer may void a policy where its insured willfully misrepresented a material fact. Most policies contain an anti-fraud provision, and the insurer must show that 1, the misrepresentation was material, 2, that it was false, and 3, that the insured knew it was false at the time the misrepresentation was made, or that it was made recklessly without any knowledge of its truth, and 4, that the insured made the material misrepresentation with the intent that the insured would act upon it, or with the intent that it would defraud the insurer. Bari was a pretty controversial decision from the start. The plaintiff in that case unsuccessfully appealed to the Michigan Supreme Court, and the Court of Appeals bound to follow it by MCR 7.215C2 and J1, thereafter limited bari's reach to policyholders in the case of Shelton, the auto owner's insurance company. Shelton held that persons that had a right to PIP benefits under the statute, such as pedestrians or motorcyclists, could not have their claims barred by anti-fraud policy language. The Supreme Court denied a leave of application in that case as well, though. A more recent challenge to bari was defended by Drew Broadus of Secrets Wardle, and the Supreme Court likewise denied leave in that case as well, which was Cobb v. Parks. More recently, we have the case of Heyda v. Farm Bureau. And against the prior history, the Shelton and bari case, it wasn't entirely surprising when the 3-judge panel of the Michigan Court of Appeals seized the opportunity to further limit bari in the Heyda case. The Heyda case essentially states that fraud provisions and no-fault insurance policies do not provide grounds for rescission based upon false statements made by an insured during the first-party litigation. So that is for instances such as getting surveillance on a plaintiff or claimant during litigation, and on surveillance, they're observed doing things that they specifically testified that they could not do. You'll have situations where a plaintiff says, I can't lift anything over 5 pounds. And then you catch them, picking up motor vehicles, for example. Bad example, but you guys kind of get what I'm saying. During litigation, sometimes surveillance shows plaintiffs doing those sorts of activities. Just by way of background, I wanted to give a brief overview of the Heyda case. There, the plaintiff was involved in a motor vehicle accident and allegedly sustained injuries to his back, neck, and shoulders. In October of 2016, the plaintiff sued Farm Bureau, claiming that it wrongfully withheld PIP benefits. And then in February 2017, the plaintiff signed litigation authorizations to release all of his medical records, and about 2 months later, he was then deposed. He also underwent 2 independent medical examinations around that same time. After discovery, Farm Bureau moved for a motion for summary disposition on the ground that the plaintiff made false statements during discovery regarding his medical history. Specifically, the medical records showed intermittent complaints of back, neck, and shoulder pain, and that at times had been prescribed pain medication in the years preceding the accident. This, according to Farm Bureau, could not be reconciled with plaintiff's deposition testimony that he saw his primary care physician for the flu, and that was it. And he said that he typically saw his primary care physician for flu-like things and was only prescribed flu medication before the accident. Farm Bureau also maintained that plaintiff falsely represented in the medical examinations that he did not have any problems with his back, neck, or shoulders before the accident. Farm Bureau argued and warranted that summary disposition under the policy's fraud provision was necessary. In response, the plaintiff argued that he testified truly at his deposition because his last 2 doctor's visits before the accident were to address the flu. And it was his understanding that the question that was posed referred to doctor's visits immediately before the accident. Plaintiff also pointed out that he had disclosed his medical records before the deposition, and therefore the defendant was aware of the medical history. Plaintiff argued that inaccurate statements at his deposition went to his credibility, which should be determined by a trier of fact. Plaintiff also questioned the accuracy of the medical examination reports, considering that he was communicating through an interpreter. The trial court was not persuaded by these arguments, finding that plaintiff made false statements during his deposition, and summary disposition was granted. But later on down the road, the Court of Appeals reversed, and in a published decision, the panel framed the issue as one of first impression. Whether statements made during litigation after an insured's claim is denied constitutes grounds to void the policy under a fraud provision. The panel found that, consistent with the vast majority of courts that have addressed this issue, such provisions do not apply to statements made during the course of litigation. This was based principally on the case law from other jurisdictions, which the panel found persuasive. Under that reasoning, false statements made during discovery do not provide grounds to void the policy because by that time, the claim has been denied and the parties are adversaries in litigation. Once suit has been brought, what is truth and what is false is a matter for a jury or judge acting as fact finder, said the court. The panel also suggested that if bari was applied to misrepresentations made during litigation, insurers might try to weaponize their anti-fraud provisions by denying otherwise proper claims in hopes of baiting the insured into making inaccurate statements and discovery. Farm Bureau thereafter applied for leave to appeal the Michigan Supreme Court, and unfortunately on June 2nd, 2021, the Supreme Court denied leave 5-2. Justices Brian Zara and Elizabeth Clement would have granted leave. Although the Supreme Court's order denying leave has no precedential weight, it has the effect of leaving the Court of Appeals' published decisions undisturbed. Because the court is not reviewing this line of cases, insurers will not only need to contend with Heyda for the foreseeable future, but also recent decisions that have also limited bari, such as Williams v. Farm Bureau. If anyone has any questions regarding this line of cases on the bari circuit, so to say, please feel free to contact me. It's been an issue that I've been particularly interested in following, so I would feel free to ask me any questions if needed. And moving on to trending topics in PIP litigation. As we all know, on May 24th, 2019, Michigan legislature passes a sweeping auto insurance reform bill, which went into effect June 11, 2019. We also did several webinars, PowerPoint presentations on no-fault reform and the effective dates. As you guys know, the Michigan No-Fault Act was originally passed in 1973. It was widely thought that no-fault reform was necessary to combat fraud and also provide options for coverage for Michigan residents and reduce the highest insurance rates in the country. Ultimately, priority rules remain the same for both named insured and resident relatives. They seek to receive coverage from their policies. However, if an occupant of a vehicle does not have their own coverage or coverage through a resident relative, they must seek coverage through the MAIPF and not the owner/operator pursuant to the old priority rules. This does not apply to someone who has opted out of coverage or has allowed coordinated benefits to lapse without notifying an insurer. And then there's also the exception of the employer furnished vehicle or vehicles for hire. For those vehicles, the employer furnished vehicles, priority remains unchanged, and the vehicle for hire also remains unchanged. Motorcycles, the old rule still applies, but any policy within the order of priority that does not have allowable expenses coverage is excluded from the order of priority. If there's no policies in the order of priority with allowable expense coverage, motorcyclists then seek benefits from the MAIPF. Pedestrians, if they are named insured on their own policy, then they recover from that. Then if there is a policy of a resident relative, they recover from that. And if not, then they go to the MAIPF. And if there are two insurers that are competing in the same order of priority, benefits are only payable up to an aggregate of coverage limit that equals the highest available coverage limit under any one of the policies. So there's no stacking, still a pro rata split, and children of divorced parents, which is where you would likely see this instance, is also a pro rata split. Now, in an MAIPF bulletin that was released in December of 2020, the MAIPF finally agreed that the 2019 changes to the order of priority took immediate effect. What we had here was insurers were providing coverage because the MAIPF was denying coverage for individuals, passengers that did not have their own policies or were not resident relatives. Specifically, changes to MCL 500-3114 Section 4 and MCL 500-3115 direct certain claimants to the assigned claims plan, who had have previously looked to the insurer of the involved motor vehicle for their PIP benefits. That is no more. And although the No-Fault Reform Bill states that it took immediate effect, on September 20th, 2019, DIFS announced through Order 19-048M that insurers could not rely on the new order of priority until they revised their policy forms. And of course, that takes some time to revise the policy forms. So then again, you were having instances of insurers still providing coverage to claimants that under the new law should have looked to the MAIPF. The MAIPF initially adopted the DIF's position. However, in December of 2020, they reversed course and formally acknowledged that the new statutory order of priority took immediate effect. So then after December 2020, we had a lot of motions for summary disposition where insurers were seeking to essentially have the MAIPF come in for benefits, to pay benefits that they originally were intending to cover. Prior to the MAIPF's December 2020 bulletin, there was a lot of division between carriers. Some accepted the DIF's opinion that the old order of priority did not apply until policies were revised, and some did not. But again, courts were going either way. In the case of Gilman v. Hastings, Secret-Swarto argued that the order exceeded the DIF's constitutional authority, and DIF's does not write or interpret statutes. The MAIPF actually opposed Hastings' position in that suit. Now, if a person or claimant or plaintiff is seeking benefits through the MAIPF, they must provide an application and reasonable proof of loss to the MAIPF. And after the claimant submits the application, the MAIPF or assigned claims insurer must specify in writings the material that constitute that reasonable proof. Interest is not required to be paid in connection with the assigned claims plan for any period of time in which the claim is reasonably in dispute. And the MAIPF must be put on notice of a claim within 1 year of the accident. It's important to note that with this roundabout change of the MAIPF bulletin, that they waived the 1 year back issue for a lot of for the claimants. The MAIPF benefit limits are $250,000 for allowable expenses. That is increased to $2 million if a lapse in other qualified health insurance coverage is the reason the claimant has to go through the MAIPF. The MAIPF may require an examination under oath within 21 days of notice, and the MAIPF may also, like an insurer, suspend benefits if a claimant does not cooperate. Indemnity or reimbursement action for the assigned claims plan must be commenced within 2 years of the assignment of the claim to the insurer, or 1 year after the date of the last payment to the claimant, whichever is later. And the assigned claims may seek attorney fees from the owner or registrant of an uninsured vehicle. And that is all for the June 2021 episode of My PIP Monthly. Again, my name is Amber Holloway, and I'm a partner here at our Troy office. I look forward to hearing from you with any questions, comments, or concerns you may have. Thank you.